Good morning, everyone. Good to see you all. Yes, we'll get started. So this presentation today is going to focus on nonprofit housing issues, specifically housing that does fall under the Residential Tenancy Act. I thought we'd open up the presentation with, sorry, I'm trying to, there we go. Open up the presentation with this really great quote from Madam Justice Sharma in a case that I'm sure all of you are probably familiar with. It's the PHS and Swaite case. And in this case, Madam Justice Sharma stated that it was a situation where the tenant was successful in their RTB hearing, and the petitioner was actually PHS in this case. So for those of you who aren't familiar with PHS, PHS is a nonprofit housing provider. They have a lot of buildings that they manage in the Lower Mainland. I'm not sure if they manage buildings outside of the Lower Mainland, but nonetheless, they were not successful in an RTB hearing, so they applied for judicial review. And Madam Justice Sharma had this to say about it. So fundamentally, the petitioner, the nonprofit housing provider, has not provided any justification of why tenants who are being given a social benefit of below market housing in an effort to try to stabilize their living situation ought to be given less legal rights than tenants paying market rates in a residential building operated by a commercial entity. And I think that this just really captures the situation that a lot of tenants who live in nonprofit housing often face, where their living situation has become such that the nonprofit housing providers are often denying them housing rights, and in some situations, their human rights, in the name of managing the building. And so for the most part, our presentation today will focus on a lot of those issues, a lot of different policies and procedures that the nonprofit housing sector typically implements in their buildings that often do result in a denial of housing rights and in some cases human rights. So I do really like this quote from Madam Justice Sharma, because it really captures the tension between the nonprofit housing sector and the folks who live in nonprofit buildings. Okay, so we're going to start with the issue of jurisdiction. So again, as many of you know, Section 4 of the RTA lists the type of living accommodations that are exempt from the Residential Tenancy Act. So this is not the full list by any means. This is just a portion of that list. But these types of living accommodations that I've noticed here are the ones that I think most of us will encounter. So one is cooperative housing. Cooperative housing under the Co-op Act is exempt from the RTA. Now, there might be situations where someone is actually renting from a co-op member, and in that case, the RTA will apply. I think that's very rare. Certainly in the Lower Mainland, it might not be as rare elsewhere in BC, but it's certainly a situation I've never come across, but good to be aware of. Living accommodation in which the tenant shares a bathroom or kitchen facility with the owner of that accommodation, emergency shelters, transitional housing, and this gem, it's quite a long one, a housing-based health facility that provides hospitality, support services, and personal health care, or is made available in the course of providing rehabilitative or therapeutic treatment or services. So the two types of accommodations we're going to focus on are transitional housing and a housing-based health facility. And so again, this is probably an issue a lot of you have encountered. You have a tenant who comes to you and they say that the landlord says the RTA doesn't apply. I think most often the nonprofit landlords who are claiming the RTA doesn't apply are usually claiming that it's probably transitional housing. That's sort of their go-to type of a limited accommodation that they will allege applies to that tenant. However, housing-based health facility, we have seen nonprofit housing sector also claim the living accommodation is. We don't see this as often as we see landlords claiming that the accommodation is transitional, but we do see it every once in a while. Some of you may see it more often than not. But basically, again, housing-based health facility, it's a pretty long one. It's got to be a housing-based health facility that provides hospitality support services and personal health care, or that is made available in the course of providing rehabilitative or therapeutic treatment or services. So the key here is it has to be a housing-based health facility. So it's got to basically have a focus on health over housing. And it has to provide both hospitality support and personal health care, not one or the other. And this is where I think a lot of nonprofit housing providers get confused about whether or not they're a housing-based health facility. I think sometimes they will claim that when they give hospitality supports, or when something that is more closely supportive housing, they will either confuse or purposely claim is what they're providing tenants. But I think that's really important when you do have a situation where a landlord is claiming it's a housing-based health facility. Again, these are the components that need to be met: a housing-based health facility, and they have to provide both the hospitality supports and personal health care. The only case where that addressed a situation where the landlord was claiming a housing-based health facility that I could find was the PHS and Swate case. So this case, it doesn't really address the grounds for the judicial review were more technical, were more about, the reasons provided, the evidence and whatnot. So we didn't really get a decision where the judge clarified what this is. But nonetheless, it can still be helpful when you are encountering landlords who are claiming that the living accommodation is a housing-based health facility. It's not defined in the legislation, housing-based health facility. And I just added a little quote there from the PHS case for you all. I'm not going to read it in the interest of time, but it is there for you if you want to reference it later on. Whoops, Okay, I actually think the RTB decision that Swate was subject to was probably more helpful. And again, if you were to look up any past RTB decisions on what constitutes a housing-based health facility, there are very few. There aren't a lot that I found. I mean, admittedly, it's been probably a year since I last checked, but when I did, very, very minimal decisions that dealt with this. But the RTB decision that was the subject of review in Swate was fairly comprehensive. And what the arbitrator said in that case was that the building was not a housing-based health facility for the following reasons. One, the operator agreement did not specify that the accommodation was intended to be a health facility. Two, the intention of government was to provide supported housing. Government was responding to a housing crisis, not a health crisis, which I think is really important to note. Because again, a housing-based health facility, as I mentioned earlier, should be health focused first, housing second. And if it's not, it's probably not a housing-based health facility. Medical supports were optional. Tenants were not required to participate in any services or course of treatment, and nothing in the tenancy agreement that suggested that the accommodation was exempted from the RTA. So I think those are really helpful guidelines. And certainly if you are faced with this situation, I think this decision could be useful. And again, if you review any of the other decisions, they all seem to be in line, other RTB decisions, they all seem to be in line with this too, sort of like it's got to really be clearly a health facility that provides housing. And again, we know supportive housing is not that. And they are very, very, very different. So I, again, did a review of previous RTB decisions, and here is a list of when the RTB has generally found the exemption applies to the living accommodation. So that would be situations where there's home support staff, there's 24-hour care aides or mental health workers on site, situations where there's an embedded clinic in the building, meals, housekeeping, and laundry services provided, emergency response call bells. One was a retirement community, very clearly a retirement community, strict noise restrictions, rules around installing life support equipment and oxygen machines. So again, you can see from this list, the focus is very much on providing health services. Okay, And so the second living accommodation I mentioned that often nonprofit landlords are claiming are exempt from the Act is transitional housing. And so again, I'm sure many of you all have encountered this situation. Again, you have a tenant coming to you and landlord's claiming, nope, this doesn't fall under the RTA. This is transitional housing. So pursuant to Section 4F of the RTA, that's the provision that says transitional housing is exempt. However, pursuant to Section 1 of the Residential Tenancy Regulation, we do have a definition of transitional housing, which we didn't always have. I think this regulation came into force in 2016, so it's still somewhat new, and that definition came about because of really strong advocacy from legal advocates and tenants saying we need some guidance on this, because just leaving transitional housing open-ended had resulted in way too many nonprofit landlords claiming they were transitional housing and being found to be exempt from the Act. So this definition really, really helps now because we have more clarity and guidance on what transitional housing is. So there are three components, and all three components have to be met. One, it's got to be a living accommodation provided on a temporary basis. This one is really important, obviously, because that is the nature of transitional housing. The purpose of transitional housing is to transition folks from either homelessness or abusive situations or some sort of temporary living situation to one that is more permanent, perhaps more independent. And so the nature of it is to be temporary. Now, there isn't a definition on what constitutes temporary. You can certainly look at various RTB cases to see what is temporary. I think, if you're going beyond the 2-year mark, not likely temporary at that point. You also have to be cautious about this provision too, because I've seen situations where, it'll say, okay, the program agreement, which is what is usually assigned that the landlord's going to take the position the RTA doesn't apply. You may see these program agreements that will have a provision in there that says, this agreement is only this expires in 2 years, or this agreement is only good for 2 years. But after that 2-year period, depending on the situation, it could turn into permanent. So situations like that, you'd certainly have to ask the question, well, is it temporary, or is this just the landlord creating a tenancy at will? Because if they have the capacity to then turn your temporary housing situation into a permanent one, then that calls into question whether or not this is transitional housing. Because again, the nature of transitional housing is its temporality. And if that's not there, if they have the ability to turn a temporary living accommodation into a permanent one, then again, that starts to look more like permanent housing that does fall under the RTA. So that's something I've noticed lately. I've also come across a decision where it was clearly a situation where the tenant did not have an end. It was indefinite. So, to us, that would seem okay. Well, it's not going to meet that first ground of being a temporary accommodation. But in that hearing, what actually happened was the nonprofit housing landlord argued the reason why they didn't put a time limit was because the tenant had some mental health issues, and the nonprofit landlord didn't want to exacerbate those or put any undue stress or pressure on the tenant. So they did what a lot of nonprofit housing providers do, which present these really benevolent arguments about, oh, we're just helping, we're just doing the good work. We didn't want to cause harm to him, so we didn't put an end date. And the arbitrator completely gave into that. The arbitrator found that it was transitional, it was exempt, despite the fact that it was clearly not temporary, and believed the nonprofit housing provider when they said, we did that for this tenant's benefit. So this one is, it's not as straightforward as you'd think. So something to look out for. The second component, it has to be operated by a person or organization that receives funding from a local government, basically any level of government. So they have to receive funding for the purpose of providing that accommodation. So their funding has to be tied to the fact that they're delivering transitional housing. And so this is I think a good component to explore a bit more. If you have the time, you can always do an FOI request, try to get that operating agreement between BC Housing and the nonprofit housing provider, because there you may see whether or not the funding is being provided for that accommodation, or whether the funding is provided for supportive housing or tenant supports. And we actually assisted a tenant in this situation where the landlord was denying jurisdiction. And we didn't have the operating agreement as evidence, but the landlord showed up and gave testimony that their agreement with BC Housing was to provide tenant supports. And because their operating agreement was to provide tenant supports, the arbitrator found, well, that's not transitional housing. So you don't meet component 2. Arbitrator ultimately found they didn't meet any of these components, which, as I mentioned, you have to meet all 3 to be found to be transitional housing. But that was, I'm going to circle back to the importance of that, of not meeting the second criteria about the funding, because it can be useful. And I'll explain that in just a moment. We also have a guideline. So we have the policy guideline on emergency shelters, transitional housing, supportive housing, which also helps to define transitional housing a bit further. I've underlined, I think, what I think is a really important part of this definition, that transitional housing is intended to include at least a general plan as to how the person residing in this type of housing will transition to more permanent accommodation. So there needs to be a plan. Again, all 3 components need to be met. There need to be services in place, but there also needs to be a plan on how that person is going to successfully transition. And oftentimes that's not there. There is no plan. There aren't supports and services aimed at helping a tenant transition at all. So I think that's another really important component that we often don't see in these situations. There aren't these plans to transition for folks. Okay. So I think there's a bit of a lag on my ability to flip through the slides. So there we go. Okay, and as I sort of mentioned earlier, there's a lot of either deliberate confusion, actual confusion amongst the nonprofit housing landlords about what the nature of the living accommodation is. And I think a lot of confusion, even BC Housing seems to be confused about the difference between supportive housing and transitional housing, because of course, as we know, transitional housing is exempt, supportive housing is not. And most of the time, in my experience anyway, it may be different for some of you, most of the time when the landlord is claiming that the housing, that the living accommodation is transitional, it's usually not. It's usually either supportive or completely independent living. And again, supportive housing covered by the RTA. And policy guideline 46, again, gives us a definition of what supportive housing is. Supportive housing is a long-term or permanent living accommodation for individuals who need support services to live independently. The Act applies to supportive housing. I have to tell you all, I've had to point to that part of the policy to BC Housing more than once to let them know supportive housing is covered under the RTA. So again, a lot of confusion, even from these nonprofit housing providers and BC Housing as well. Okay, I thought I'd kind of go over, a bit about tenancy agreements and program agreements. I talked about program agreements earlier. I'm sure many of you have seen these program agreements, which again is usually a sign that the landlord's going to take the position that the living accommodation does not fall under the RTA. Again, I think as most of you know, tenancy agreement can be written or verbal. There also are these standard terms that have to be in a tenancy agreement. So if it is verbal, it doesn't matter that you don't have a written document, a written agreement. These standard terms will apply, and standard terms include things like you can't change something unilaterally in the tenancy agreement. And again, I think you all probably know once a tenant signs a tenancy agreement, they don't have to sign any subsequent tenancy agreements unless they agree to do so. A landlord can't unilaterally change terms. A landlord can't unilaterally give a new tenancy agreement and tell someone that they have to sign it. Despite that, though, most of us know that this happens, that landlords will pressure tenants into signing addendums or signing new tenancy agreements, and tenants aren't always sure whether or not they have to or not. And so one practice that I've certainly have seen is tenants who have tenancy agreements that are recognized under the RTA will sometimes receive addendums or be told to sign another tenancy agreement that says that the living accommodation is transitional, the act doesn't apply. And I've seen this in situations where sometimes you have a change in management. Maybe one nonprofit is no longer managing the building. You have a new nonprofit. That new nonprofit wants to be able to manage their building without having to observe the RTA. So I've seen this happen where they then give tenants these new tenancy agreements saying this is transitional, the act doesn't apply. Of course, that doesn't matter because parties cannot contract out of the RTA. So if this happens, if you get a tenant who said, oh, I did have a tenancy agreement that said that was under the RTA, but then I had to sign a new one that said, the act doesn't apply or this is transitional housing, that new tenancy agreement is probably not valid. Again, you can't contract out of the act. And what this all comes down to is what is the nature of the housing? So just because a landlord says, hey, the act doesn't apply, or sign this new tenancy agreement that says the act doesn't apply, doesn't mean it doesn't apply. Because at the end of the day, there's still those 3 criteria that need to be met for a living accommodation to be considered transitional. And there's no contracting out of the act. So those agreements or those addendums that sometimes nonprofit housing providers get tenants to sign usually have no force or effect. You can't just decide all of a sudden the RTA doesn't apply. Okay, and so program agreements, again, I'm sure many of you have seen these. And I've even, there's been another iteration that I've seen where they're not even calling them a program agreements. It's something even less committal. I forget the name of it, but it's just like, a clear attempt at the nonprofit landlord trying to make it very clear, like this isn't a tenancy at all. This is just a program or something else. So again, Section 5 of the RTA says parties can't contract out of the act. A lot of these program agreements will say the act doesn't apply. It doesn't matter. Even if your client has signed a program agreement saying the act doesn't apply, it doesn't matter because again, you cannot contract out of the act. You can also, when you go through a program agreement, I think it's good. Sometimes these program agreements are valid and they are just program agreements and it is transitional housing. It's a good idea. Obviously, as you all know, look at that program agreement. What does it say? Are there indicia of a tenancy agreement? Any components of it that start to resemble a tenancy agreement? Or that it's more likely a tenancy agreement than it would be something temporary, transitional housing. So examples of that type of indicia are, the duration. Is it temporary? Is there an option to stay permanently? Which I brought to your attention earlier. Rent. Is the tenant paying rent? Did the tenant pay a security deposit? Are there supports and services being offered? Are those supports and services mandatory? So through looking at what's in a program agreement, you can often tell whether or not it's starting to resemble a residential tenancy. And you can certainly point to that in the hearing if you do assist a tenant with challenging jurisdiction at the RTB. Okay, so that was jurisdiction and tenancy agreements. Now we're going to go into maybe some of the more substantive components of the RTA and how those components affect tenants in supportive or tenants who are living in the nonprofit housing sector. So health and safety and housing standards. So Section 32 of the RTA states that a landlord has to provide and maintain the residential property in a state of decoration and repair that complies with the health, safety, and housing standards required by law, and having regard to the age, character, and location of the rental unit makes it suitable for occupation by a tenant. So we know landlords are responsible for maintaining the building. And we also know that a lot of landlords, a lot of nonprofit housing landlords, allow their buildings to fall into disrepair or deny tenants that standard that they are supposed to follow pursuant to the RTA. And so there was a BC Supreme Court case that did address this. This was a case, it's called Rutherford and Neighborhood Housing Society, where the tenant had made numerous complaints, maintenance complaints, repair complaints, and the nonprofit housing provider was just not taking care of those complaints. And so I think this is an important excerpt of that decision where Justice Bruce stated that, okay, where's the relevant? Okay, says, in my view, it's a patently unreasonable interpretation of the act, and on the face of the record, it appears discriminatory against the tenant. A tenant who has limited resources and is therefore forced into a neighborhood that may have problems with neighbors is entitled to the same standard according to the act. That is according to all other tenants. It seems to me that the arbitrator, if he in fact interpreted provision of the act in this fashion, has engaged in a patently unreasonable reasoning. More likely it is apparent from the lack of reference than a reference to the right to be free from unreasonable disturbances that the arbitrator failed to consider that section at all. So in addition to the repairs and the maintenance that the tenant was requesting in their application, they were also making complaints about noise. And so this paragraph speaks specifically to the noise complaint, and the landlord, the nonprofit landlord in this case, claimed that, well, it's a noisy neighborhood. There's nothing we can do to solve that. And again, they used the location of the building being in a low-income neighborhood as justification for why they weren't addressing the noise complaints, why they weren't addressing the maintenance and repair issues. And the judge, much like Madam Justice Sharma in the quote I opened with, just said, no, there's no justification for why someone who lives in nonprofit housing should not be afforded the same standard as other tenants. So again, you start to see a pattern amongst some judges that recognize that, and hopefully judges continue to recognize that moving forward as a lot of these nonprofit issues make their way to court. Okay, so that's it for me. I will now turn it over to Lex.
Yeah, so I will be talking about guest restrictions primarily, but also a few other unique issues related to supportive housing. I think, guest restrictions are important to know. It is protected. The primary protection here is in section 31, where it says landlord must not unreasonably restrict access to the residential property by a tenant of a rental unit that is part of the residential property or a person permitted on the residential property by the tenant. And they also have a little extra bit in the regulations that says, landlord must not stop the tenant from having guests under reasonable circumstances in the rental unit. The landlord must not impose restrictions on guests, must not require extra charge, and so on. So I think the area of guest restriction is interesting for a couple of reasons. One is that, in one hand, it's an area that's not that a lot of judges and arbitrators seems as not so serious because, the tenant can still live there. They're still getting their heat and water. They're still able to, do the primary purpose of a tenancy, which is living there. On the other hand, a lot of these guest restrictions that the tenant face actually, when the tenants come to me, and I specialize in, downtown east side and a lot of areas that have very serious guest restrictions. A lot of the tenants who come to me is like, they are telling me they feel like they live in a prison because they cannot have guests. They have to be bussed in. They have to show ID when you go in. And I have visited several clients who live in these buildings, and it is pretty, like, you do feel like you're going into a certain, okay. You do feel like you're going into a certain, like, you're not going into an apartment building, you're going into some sort of restricted facility, right? Like, even when I come in, I have to go to the front desk, I have to show my ID. I have to get my name written down. I have to go in, and all of these things are, as we'll get to, illegal. And I think a comparison I personally like to bring up in my hearings is whenever you can, take a look at the rules for a prison and just see if they're worse, if the prisoners have more rights than your nonprofit tenants. And in some cases, you might find that they do. For example, the most common guest restriction is probably like tenant can't have guests for more than 14 days a year. 14 days of overnight guests. Prisoners in Canadians' correctional facilities are actually allowed 18 days of overnight visits a year. The specific rule is the duration and frequency used for the private family visit units will normally be up to 72 hours every 2 months unless otherwise specified by a standing order. So those are the rules for visiting prisons, which that would account, that's 3 days every 2 months, which is more than 14 days a year. So that's a fact I always like to bring up when I'm disputing that particular guest restriction. And arbitrators seem to like that too, because there's often like a lack of understanding of how serious a grip into the tenant's life that these restrictions are. Another reason that the area of guest restriction is a little bit unique is that it's one of the few areas where we actually have not just one, but like several Supreme Court decisions on this case, on this area. And that's because it's an area where the landlords are usually very defensive. Like they care a lot about protecting these rules. For example, like when I'm out there doing evictions and stuff, half the time the landlords aren't particularly prepared when they show up to the hearing. Contra, like whenever I try to take a guest restriction case, usually they will retain like a law firm to defend themselves. So these are rules that they are very, for some reason, they feel is very important to them. So one of them, as Danielle talked about it a little bit, is Atira v. Richardson. So in this case, there were a lot of guest restrictions. There was restrictions on overnight visitors. People had to show ID at the door. And as this will be, if you ever do these cases, the landlord usually won't say why this person's rights had to be, why the person's rights to guests had to be limited, but that because, they live in a dangerous neighborhood, they have problems with tenants, there's a lot of unhoused people around the area maybe, and that's why they need these policies to restrict everyone's right to guests. And Richardson's simply say here, the part that's important is it does not, and I am of the view that the arbitrator correctly assessed the intention of the statute to be to protect individual tenants and their guests from reasonable interference by landlords. It would be wrong in principle to permit the protection offered by statute to be eroded by ad hoc non-statutory policy instruments promulgated by landlords, however well-intentioned. So that's basically saying, like, you cannot have a policy to do guest restrictions. If you want to restrict someone's guest, you have to be like, okay, this person, you have had this guest over, that guest has caused problems, we are banning that guest. It has to be related, the reasons have to be related to the person, not to the building or the neighborhood. And he goes on to say, that the arbitrator's reasoning in this case, the arbitrator didn't comment at all on all the things that the landlords were talking about in the neighborhood. And he said, that's totally fine because that doesn't matter. What matters is why was this person's guest restricted? And another one that Danielle also mentioned is PHS Community Services Society v. Swait. There are standards, you can't, and people who live in low income supported housing or nonprofit housing, they each have their right to guests is the same. So if you could not restrict those people who live in those top of the line, $10,000 rent apartments, then you cannot restrict them in nonprofit housing. And I think that's a good argument. You should always bring it up. And it goes on also in Richardson's, the same thing, the neighborhood can't be, you have to personalize your control over the guest restrictions. You cannot just do it broadly. And I just want to mention briefly that during COVID, a lot of people saw ban on guests and completely building wide, no exemptions. Like I had people had their health providers be denied entrance, people who came to help clean their apartments and stuff, denied entrance, close family members, advocates like myself, no one was allowed to enter those buildings. The class and some other nonprofits, including TRAC as well, they designed a letter, which is good. I think you can give it to the landlord. I think COVID restrictions are loosening many places. But yeah, it's clear. COVID, there were never any restrictions in COVID saying like, you can just ban all guests. That's fine. You could never do that. And like, even when the COVID restrictions were the most serious, people living alone could still have a bubble of like 2 other people. So there were never like a point in time where, according to COVID restrictions, a person was allowed 0 guests over. Even if there were, it wouldn't have been the landlord's duty to enforce it, but there actually never was a time where like there was a total ban on having people over. Again, just to highlight that, and I think it's always important that you do this, highlight the serious consequences of these guest restrictions to the arbitrator. A lot of people are dying because they die from drug overdoses alone. They are alone because of these guest restrictions. They were more alone during COVID. And like the safest way, of course, is to have the body system, that you have someone else with you when you use, so they can do something right away if something goes wrong. And a lot of landlords are just completely ignoring this. And what's even more frustrating is that like they're clearly ignoring the actual advice groups from experts. And as we'll talk to later, they will come around and say like, well, we need to do wellness checks to make sure people are safe and that people aren't overdosing. So like they're just doing policies that directly oppose each other's goals. But I want to do so what can we draw from this area of law? Like we have a lot of Supreme Court cases. The RTB decisions are also very consistent. Like every time I have I do a new case, I review like, okay, what's the latest RTB decisions on guest restrictions? And it's an area of like, there's almost never any success from the landlord side. But I want to maybe paint with a big brush here. The questions I think are, are all regress restrictions in a first-time tenancy agreement illegal? That's an interesting question, and it's something I thought about. And I think, to be clear, I think the answer is yes. I don't think if you don't know the tenant, if that tenancy agreement has any restrictions at all, I don't care how reasonable the restrictions are, they are probably illegal, because if you don't know the person, it's a policy, and a policy is illegal. So that includes like the 14-day thing, which is very common. That includes ID, that includes like extra charges for having a guest over. It could include like, even if they're very benign, let's say it's not 14 days, let's say like the guest policy says you can only have guests like 45 days a year. I still think you just cannot put any guest restrictions in your tenancy agreement if you don't know the person. And the ones you put in there has to be related to the person. So I think your starting point when you see a guest restriction should just be like, okay, that's illegal. Like you see it, it's illegal. You don't really need to consider too much about the reasonability, again, because like the reasonability is related to the person, not the building or like a general concern. I think the one exception might be like, you can't have more guests than allowed by the fire code. Something like that might be like, okay, well, that's a law, so that's probably reasonable. But despite the consistency of both the RTB and the Supreme Court on this issue, where are we actually today? Well, we are there at that, the non-profit housing providers are basically just ignoring the law. Like, you go to them, you show up, you say like, look, there's Richardson, here's Pat, here's this, here's all of these RTB decisions that say you can't do these guest policies. Your policies are identical to the decisions, to the policies in these documents, and like they're illegal, so you have to stop them. And they just say like, okay, I don't care. We have guest restrictions, we don't care. And I think we have to think if there is a new way or a different way to approach these issues. And I think because like if I were to, let's say, just start suing landlords, I would have to sue them one for every tenancy in all of their buildings to end the guest restrictions, right? So I would have to do like just from like the nonprofit housing providers in like my small section, right, downtown east side, I'd have to do like 4,000 applications. I'd be doing like a hearing a day for like 10 years. Because they, as I said, they just don't care. Like as I said, like class has that beautiful letter, you show up with it, they're like, yeah, we're just gonna do it anyway. So I think an approach needs to be taken where we involve the compliance and enforcement unit, because they're really more suited for cases where the landlord continuously break the law without where the law break is clear and they just continue to do it. You need, generally, I think you would need a director's order, and I have been successful in my most recent guest restriction hearing. I got the arbitrator to say the following: I caution the landlord not to include 14-day guest policies in any future tenancy agreement, and that by doing so could lead the landlord to be recommended for investigation by the RTB Compliance and Enforcement Unit. Right, so now if I have another case with that landlord, I will just go to the enforcement unit. I will say, look, I have a director's order here saying these are not allowed, they're breaking it, can you please do something? And all we can really hope is that they do something, because, as I said, there's no way you have the manpower to lift it from like every tenancy by doing individual cases. It's just like mathematically impossible. And of course, another problem is like, you're out there, right? You have to prioritize your cases. Do you take an eviction case or a guest restrictions, right? Like most of the time you take the eviction. So it's, it can be difficult to fit like thousands of guest restrictions into your work.
Lastly, there's a question in the chat about whether these guest restrictions have always been illegal or only after the judgments in the cases that have been cited. This person used to work in BC Housing, and she said it was a practice that she was unwilling to enforce. So I guess essentially, have they always been illegal or only after the judgment in the cases that you talked about?
Well, I mean, I think the way judgments works is that it's always been illegal, but it was very clear. It was perhaps less clear before the judgment, but in my opinion, it has always been illegal, because the rules for like unreasonably restricting access of guests have not changed, right? So there's been no legislative change. So, but I do think like maybe the total ban on guest restriction is a little bit wider than some people could have expected. Like I'm in favor of it, and I think that is what is meant with the law, but I don't think it's impossible that it could have gone another way. But in my opinion, it's always been illegal. And I don't know, I've talked to BC Housing so many times. Whenever I get a new decision, I'm like, hey, BC Housing, your 14-day is still illegal. Could you please take it out of your tenancy agreements? And I never get any answer. So yeah, I think I don't know if they're just, if it's slow. And then Sanya is asking like, hey, Lasse, where's that quote from? Can you share that decision? And I'm assuming she's talking about this. I caution the landlord not to include 14-day guest policy. Yeah, I think I've already shared it on PovNet, but I can definitely send it to Louis after the presentation, and I don't know, she can share it however she.
Sure, I can put it up on. I'll put it up on the shed, like the shed session here, this session, so you can find in the materials for this session. Yeah,
and I think I'll also throw in. I tried to, just because I think I have more expertise with that, so I did like try to write out like basically just like a fillable form for guest restrictions where like all of the decisions are already in there, and like I already pre-wrote the arguments with like anonymized, like without names, of course, because there's nothing there. So I'll throw that up as well, so you have like an idea of like how I approach these guest restriction hearings, because I almost do it the same. By now, it's almost like copy paste for me, because I've done so many of them. But yeah, to get back to the presentation, yeah, I think somehow the employment and enforcement unit is involved. So like whenever somebody, I think we should try to put some pressure, maybe different advocates, if you're in the same situation, we could let us know, or maybe through PovNet, if people can be like, hey, I got this decision against this housing provider, then if we can gather which housing providers we have director's orders against, so it would be easier to contact the compliance and enforcement unit. I think that could be a good case for like some teamwork between advocates.
There's also a question of whether the guest restrictions are applied to transitional housing.
I mean, yes, if it's actual transitional housing, it's obviously exempt from the act, so it doesn't apply. But like Danielle said, if you don't think it's actually transitional housing, then it does apply, because then it's just a normal tenancy. Again, just to be clear, you can never you can never justify a guest restriction by a policy or the neighborhood of building you're in. You have to, the landlord has to think, and it's very important, like whenever you go into the case, you have to just make sure that the arbitrator understands that this is about a person. It's like, you have this person. Why can't Peter have guests? Landlord, tell me, why can't Peter have guests? I don't care about the building. I don't care about everything else. Why can't this person who has never done anything have guests? That's basically what is the most important thing to hammer down, and I find that's the most effective thing to do for arbitrators to not buy into all of those, as Danielle said, like benevolent arguments of the landlord of like, oh, we just have to do this because like we're just, we're just trying our best here to provide some scarce housing for these poor souls, and this is the only way we can do it. Okay. All right, so that's, I want to talk about something else. There is, of course, the problem of like, okay, so guest restriction, you can't restrict guests. That's fine, that's known now, but you can restrict occupants. Like you can say like the tenant's not allowed additional occupants. That's a legal rule that basically every nonprofit has in their tenancy agreement. Can't have additional occupants without the landlord's permission. And usually also your rent would have to be recalculated if you have an additional occupant. And some landlords, if they're a little more clever, they'll try to do that. They'll be like, no, okay, it's not a guest restriction, but this person is an occupant, so we are increasing your rent. Right? That's also a violation of guest restrictions if that person is not actually an occupant. So the occupant problem is that, when does a guest become an occupant? I think almost the only characteristic that matters is whether or not the person has another place to live, except where he is now. That's what you want. Whenever a tenant, you pick up your phone, tenant says like, hey, I'm being evicted for having an extra occupant, or like my guest has stayed too many days. First thing you want to ask is like, do they live another place? Yes. Okay. Can you get me some evidence that they live another place? Basically, the first question you want to ask on your mind. If you can prove that they live somewhere else, I think in most cases the landlord will fail, because no matter how long they stay there, doesn't seem to matter. And there's a lot of RTB decisions on this one. For example, these are all my cases, but in the first one here, it was the tenant's son. They were part of a shared custody agreement. So 50% of the time he stayed with the mom and 50% of the time he stayed with the father. But the mother was the primary custodian. And that's where he was registered as living. And that's where like all his school papers went. That was his school district and so on. So tenant hadn't said he had an extra occupant because his son was just visiting, but we're talking, half the year here. So like every other week. So like 15 days a month he was there, right? And still the arbitrator found that given the supported evidence that the tenant's son resides with its mother, I find on the balance of probability that the son only stays with the father as part of a custody arrangement and does not occupy the unit as a full-time residence. And he said, all right, so he's not a guest. He's a guest, basically. And that's like half the year, right? So that's quite a long time. You can still be a guest as long as you maintain your primary residence elsewhere. The second case here was a tenant's girlfriend who was over very, very frequently, like maybe 4 days a week. She'd usually come like from first day, leave late Sunday. Arbitrator found, based on the evidence presented by the agent for the tenant, I determined that at the present time, the agent for the tenant is living elsewhere. As a result, he is a guest and not a, boyfriend, not girlfriend, but as a result, he is a guest and not a resident. So again, no regard for like the number of days, no regard for like how frequently he was visiting, just whether or not they had another place to live. And I will say, even in the something I also like to point out, because obviously you will, most of the time when you're in nonprofit housing, you're going to go up against tenancy agreements that are modeled or like a direct copy of the BC housing agreements. The BC housing agreement, the standard one, in section 15 says, the landlord may require the tenant to provide proof that the guest maintains a primary residence elsewhere. That will be in most of the tenancy agreements you see when you're working with nonprofit housing. And you can just say like, look, the landlord already acknowledges this, like that if a tenant can prove they live elsewhere, then they are still a guest. So good little detail to bring up if your agreement does have that, is like, look, the landlord doesn't have to guess. They already put like a way for them to control this in their tenancy agreement, and they can just use that way. The tenant for this hearing has already provided proof that they live elsewhere. So yeah, good to know. That does, of course, leave like the problem that some of my tenants have, right? Like what to do if their guest is unhoused. Some people who, you know, come from unhoused has only been recently housed. Many of their guests may still be unhoused. In that case, I think you have a more difficult proposition of like convincing the arbitrator, because, you know, the people who are unhoused face a lot of prejudice. I won't go into it in here, but like a lot of assumption is made about them that are simply not true. But your case is more difficult. Of course, you'd still just argue, you know, there's no specific limit of days. They haven't stayed there long. They don't stay there permanently, and so on. But it's definitely, my most difficult cases are when the tenants have unhoused guests, because that does pose a unique problem to. It makes, if a person doesn't have a home, the arbitrator is very likely to believe that they live with your friend. And if you have no evidence to disprove that, you're going to have an uphill case. So I just, you know, I want to flag that. I want to say I don't think it's impossible, but that can definitely be a problem. All right. So going away from guest restrictions, another unique problem to nonprofit housing is whether or not a tenant is over or underhoused. Now, in market rent, no one cares whether or not you're underhoused. Whether or not you're overhoused. Like if you have too many rooms to live in, like the landlord doesn't care, right? Like as long as you pay your rent. But obviously, BC Housing has a duty to provide housing to as many people as possible, and they can't allow people to live in places where they are like one person alone in a 4-bedroom. That's obviously not their mandate, right? The actual national occupancy standard are a maximum of 2 persons per bedroom. Household members of any age living apart as married or common law couple must share their bedroom. Parents in one parent family have a separate bedroom. Household members age 18 or over a separate bedroom, except if they're living with their girlfriend. Under 18 years old, of the same sex, can share a bathroom, and household members under 5 of the opposite sex can share a bedroom as well. So BC Housing has made a little bit of a simpler, less wordy rules. It's just there should be no more than 2, no less than 1 person per bedroom. Spouses and couples share a bedroom. Parents do not share a bedroom with children. Dependents age 18 or more do not share a bedroom. Dependents age 5 or more of opposite sex do not share a bedroom. And these occupancy standards are, I mean, they're not in the act, right? And they will typically, they might not even be in the tenancy agreement. So you might sometimes have a argument from just a perspective, like the tenant never agreed to this. But I also want to, just before we go into the presentation, I want to say that I have faced quite a lot that the nonprofit housing sector tries to say, like, BC Housing told me I have to evict them. They told me they're going to stop the subsidy. In every case where a nonprofit housing provider has told me that has been a lie. BC Housing generally do not direct them to do things like that. Like, they exert general financial control over them, but they never tell them to, like, you have to evict this tenant, we're not going to pay anymore. So if you ever hear that from a nonprofit housing provider as an argument, make sure you double check with BC Housing whether, like, hey, do you guys say anything like that? And also another myth that I hear from a lot of tenants that's just factually untrue is, like, well, if you stayed there like a really long time, they can't evict you for being overhoused. I don't know who invented this idea, but I hear it like probably like once a month. Someone will be like, well, I raised my children here, it's my home, they can't, like, force me to leave. That's just false. Like, you have no extra protections for having stayed there a long time. So I'm sure you all knew that, but, like, just because it's something that I face a lot, I just wanted to let you guys know that that's definitely not true. So I thought to actualize these rules, we could go through a life cycle of a family here. So at the start, this is a 6-person family in a 3-bedroom apartment. They have 2 children under 5 and 2 children between 5 and 18. Now, I want to say, before I start this presentation, there's a very fascinating from a legal perspective, obviously horrible for the people living in those situations, but there's a lot of fascinating aspects of this cases regarding transgender issues, because the law is old and it operates strictly based on sex, and it's difficult to say, like, whether it's a human rights violation if trans people suffer, like, are considered under or overhoused as a result of them transitioning or identifying as a different gender than the one they're born as, and how landlords will agree to that. And I'm not going to get into that because I simply don't know the answers to that. But if anyone has a case like that, I think it's very important that you bring up a human rights angle. And I also want to say that's why I use a bit of like simplified iconography in this presentation. Well, one, limitations of the technology of my time and PowerPoint, but also because the law is very like, there are two genders, women, men. No changes ever happened to that. So we're just not going to consider it. And yeah, so whole host of interesting legal situations there, but I simply can't answer it. And I will give another example. Like, I'm only treating overhousing here because I saw the question in chat about underhousing. Because underhousing most of the time, I mean, they're just going to put you on some ridiculous waiting list. And in my opinion, there's not too much you can do about it, right? They're like, oh, you're underhoused. Okay, yeah, well, you'll get the next apartment that opens up. Please sign this application. You sign it. If you're lucky, something happens. A lot of the time, nothing happens. I don't think from a legal perspective, there's not much you can do, at least at the RTB. You can't like force the RTB to issue an order that the landlord has to give you a new tenancy with adequate housing before a specific date. I don't think that's possible. But today we're going to deal with overhousing, which typically when the case comes to you, it will be a case of an eviction. Like, hey, landlord says I'm overhoused, they're evicting me. That will usually be how these cases come to your attention. So it will usually be an eviction hearing. But yeah, let's go through the life cycle of this family. So right now they have 3 bedrooms and they have 6 people, 2 males and 2 under 5. Are they overhoused? And I want you to, I'll give you just like 5 seconds to think about it every time before I give an answer, just so you can try to follow along. So no, right now they're not overhoused. They have a maximum of 2, minimum of 1 per person. So they're following that. There are 3 rooms, 6 people, so that's fine. Under 5 can share with any gender, so it doesn't matter what the gender of the males doesn't matter, because the 2 males can stay in 1 bedroom and the 2 babies can stay in babies 0 to 5 can stay in another bedroom, and they're following all the rules. So one of the person grows up. Are they overhoused? No, still the same. The baby can share with doesn't matter that one of them turned over 5, they're still good. Now, the last one turns over 5, is a female. They're not overhoused for sure, but they are now underhoused. So the male and the female, since they're both over 5, they cannot share a room together. And the 2 males can. So again, interesting issues if what if the female identifies as male, but we won't get into those. Just in this case, they're underhoused now, and they could give an application that they want a 4-bedroom, which is what would be needed to house this family. But let's say an accident happens and 2 of the children die. They are now 4 people in a 3-bedroom. Are they overhoused? And I think now we're entering into a gray area. I have argued, I've received cases like this where tenants have been given an eviction notice for being overhoused. In these specific scenario of 4 people in a 3-bedroom. Now, what the housing provider will usually argue in these cases is that they can fit into a smaller apartment. right? They could live in a 2-bedroom apartment and they wouldn't be underhoused. That is correct. But I don't, from the description, right? If you just go back and look at the occupancy standard, there's nothing saying those are maximum and minimums, right? So in my opinion, it means that there's room for a couple of living situations between being underhoused and overhoused. Whereas the housing providers tend to see it as a binary option. Like either you're housed to the maximum capacity or you're overhoused. I don't agree. And in this case, I think they are not overhoused because they are 4 people in a 3-bedroom. The parents have to share, fine. So the important in the occupancy standard is like, it says people between 5 to 6 of the same age can share a bedroom. It doesn't say have to. Doesn't say have to. And that's very important. So I think you can say in this case, if there is an eviction notice, just be like, no, nothing in the rules that says they have to. They're above the minimum, which is 1 person per bedroom. And there's nothing wrong. There must exist several situations between like minimum underhoused and overhoused. There must be a wide array of configurations where the person, they're just adequately housed. Yeah, sorry. So yes, there is a minimum of 1 person per room. Yeah. Well, the gender is the kids I'm showing here, right? Assume that the kids have the gender that I'm showing. Okay, so let's say one of the kids grow up. He's now 18, still dependent, living at home. Is he now overhoused? Are they now adequately housed? Are they still underhoused, overhoused? What's the situation? And yeah, the answer is now they're definitely adequately housed because people over 18 have to have their own bedroom. So now there are no longer any issues with that. So they're adequately housed now. And let's say one parent leaves. Yes, as I said, she's the 18-year-old is a student and a dependent. Husband leaves. Are they still? Does this change anything? No, they're still 3 people. Parents have to have a separate bedroom, so can't share with the 5 to 16-year-old. 18-year-old has to have a separate bedroom, and the 5 to 16-year-old can share with another one in their position or a baby, but there are none, so they're okay too. So 3 people, 3 bedrooms, this is still fine. Now, I won't get into the reasons why, but let's say the kids are temporarily removed by the welfare ministry while the mother receives some help from them. Temporarily removed, they will be back. Is the mother overhoused now, alone in her 3-bedroom? So I think that's an interesting question, because often the problem you might have is, the way you want to think about it is like, okay, let's look at the Residential Tenancy Act. Do they still count as occupants or tenants? Probably. They haven't abandoned the property, right? Abandonment means like there's no expectation that you're coming back. They haven't removed their belongings, and they are probably frequently visiting, you typically, you know, you in this kind of things, you like phase them back in slowly. One problem I experience in cases like this is that the welfare ministry will often not give a deadline, like for very good reasons. But if you contact them to help with your case, they'll say like, well, we don't know when the kids can be returned. We're planning to return them. Like that is the plan. And we can give you like, what's the next 3 months going to look like, but we can't tell you what the future is like. And in my opinion, I agree with most of you. She is not overhoused, but I will say I have also received eviction notices for in situations just like this. As long as there's an expectation to return, as long as their belongings stay there, I don't think there's grounds to evict her. And obviously in this case, you also really have the humanitarian aspect on your side, like not just the legal aspect, but like the, look, if she doesn't have these bedrooms, she can never get her kids back. And just the last thing is like, let's say the welfare ministry didn't remove it. Let's say the father got the majority of custody. Let's say the mother only have the children from Friday to Sunday. Is she overhoused in that case? And I think here we're really in a gray area. I'm leaning. So someone is correctly mentioning here that there is a 40% rule. I will say like that 40% rule is just like completely made up by BC Housing. It's not a residential tenancy agreement rule. But I do agree there is a gray area. There is an area of like, there are probably guests. So they are no longer entitled to their rooms. I think if you want to get creative, and I have done this before, if you want to get creative, you could say like you could use an estoppel argument where you say like, look, you say people stop being guests after 14 days a year. I'm not going to talk about the legality of this, but that is your definition, landlord, that people are an occupant if they're staying more than 14 days a year. So since that is your definition of an occupant, you can't now say that they're guests. You're stopped from taking a different position. And therefore, these people are, according to your definition, still occupants, and therefore she's not overhoused. But obviously, that's not, whenever you're arguing estoppel, your back is against the wall. But I don't think it's an impossible argument to win. And I have advanced it before. Unfortunately, on this area, all of my cases, despite having quite a few, none of them ever went all the way to the hearing. All of them, for one reason or another, ended before the hearing. So I don't actually know what any arbitrator thinks on these interesting gray areas. And I can see, in the interest of time, I'm just gonna speed up a little bit through these, the last two here. Quiet, peace, and enjoyment. This is not really specific to nonprofit housing. The only things that I think are important to pay in mind is, like, as Danielle mentioned, one, the people have the same right to be free from noise and disturbances as tenants who live in more high-end housing. The tenants don't have to put up with disturbances just because they happen to live in low-income housing. The landlords still have a duty to secure their quiet, peace, and enjoyment. One specific example here is also the landlord's right to access to the unit under quiet, peace, and enjoyment, right? A lot of these places will have these wellness checks. That's basically like, oh, if we think we haven't seen the tenant in 24 hours, we can enter. We can just go in because they overdose all the time. And I like a lot of them will even have their like managers or stuff carry, I forgot what the drug is called, Naxatone or something like that. Just like an additional argument. And most of the time, these wellness checks are just used to harass tenants. Like they'll just be like, oh, going in, oh, you're there, you're totally okay. Oh, whoops. Oh, since we're here, we do want to just like check this other part of the unit anyway. And it happens all the time. They cannot be imposed on the tenant. They're a violation of their quiet peace and enjoyment. If the landlord continuously abuses them, you can just you can apply. If it's very serious, you can even apply to have the locks changed. Another piece that's unfortunate in regards to low-income housing is like usually when you do an application for quiet, peace, and enjoyment, you would ask for like a percentage of the rent reduction as damages, which obviously in the case of nonprofit housing, the rent is extremely low. So whatever, like even like a big reduction of like 25% less rent per month is going to come out to like $80, maybe less. So sometimes it can be difficult to justify doing the cases. But yeah, all legally valid, no lesser right to quiet, peace, and enjoyment. And these wellness checks are definitely illegal. Of course, landlord can, as in all other places, they can enter if they want to expect for damages, carry out repairs, but they can just give the normal 24-hour notice. And like a thing you want to say when the landlord brings up like wellness checks, just be like, well, you can already do that. You don't need to put that in a tenancy agreement. If you actually have proof or strong suspicion that this person is dying in the tenancy unit, then you can open because you can enter in an emergency. These wellness checks are not a part of that. There's absolutely zero reasons for that you need to put them in your tenancy agreement, because if you actually think someone is dying, you can just enter. But you can't make like a weird rule that if you don't see them for like X amount of hours, then you assume they're overdosed and you can enter their apartment. And I think, Danielle, if you want to swoop back in.
Yeah. And just one thing I also want to highlight when Lasse and I are talking about guest restrictions and wellness checks, where it becomes problematic is the imposition, the building-wide imposition on tenants when they're not asking for these things. Surely wellness checks, some guest restrictions and circumstances, some tenants may welcome. But the problem is this paternalistic approach where there's just this assumption that all tenants want it or need it without actually asking them if they want it or need it. So rather than impose guest restrictions or impose wellness checks, these nonprofit housing landlords could ask, is this something you would like for us to do? And it's about respecting the autonomy of tenants living in nonprofit housing that's needs to be observed. And that's the problem. It's the building-wide approach, the assumption that everyone needs it or wants it without actually speaking and communicating and seeing whether or not that's what they actually want. So we just want to be clear that we're not saying, these things are horrible, they're bad. Surely, yes, there are some tenants who may feel they want to restrict someone that is not good for them in their life. Absolutely, they can ask the landlord to do that, and that could be good for them. Or again, someone may ask a landlord, I think I could really benefit from a wellness check. That's good, but not everybody wants that. And to impose that on everybody, to evict people if they're not compliant with that, specifically in the guest restriction situation, which I'm sure many of us have seen. Clients want to bring in a guest over, and because that guest maybe doesn't have government issued ID, or they want to have a guest stay over, we see landlords move to eviction in these circumstances. So again, it's nuanced, and it needs to be approached on a case-by-case basis, not unilaterally, because again, that's where this paternalistic approach comes into play and can be very harmful. So I do want to move on here. We have about half an hour left. I want to talk a bit about the compliance and enforcement unit. So Lasse already sort of talked about the compliance and enforcement unit. He had that really great case with the arbitrator reference the compliance and enforcement unit as being a possible next step for a landlord who may continue to violate the order that said, hey, you can't have these guest restrictions. And so for those of you who may not be super familiar with the compliance and enforcement unit, it's relatively new, and it may be useful to address a lot of nonprofit housing issues, including the issue of jurisdiction. And I think some of you may have already, I've already maybe talked to you about this before, or have heard me talk about this in other venues. But I had a client who, was in a nonprofit housing building. Landlord claimed RTA doesn't apply to this building. So we assisted her in challenging this argument about jurisdiction. And I mentioned this case earlier where the arbitrator found that the nonprofit landlord did not meet all three components, but it was that second component about funding that was important. Because surely if a nonprofit housing landlord does not have funding to provide transitional housing, that will be applicable to all tenants. That wouldn't just be applicable to one tenant. And I think part of the struggle here is we may have tenants living in these buildings where the nonprofit landlord is denying jurisdiction or imposing guest restrictions. But the only way that can be addressed is through individual complaints, which can be very onerous. So is there a way that rather than individual tenants having to go and apply to the RTB for dispute resolution to get these decisions, is there a way that we can get a positive decision and have that positive decision apply to everyone? And I think this might be a way we can try that. And in this case, it seems like it actually works. So because, again, the landlord in this case, nonprofit landlord, didn't meet that criteria about funding, and because the compliance and enforcement unit actually now takes third-party complaints, which means any of us can make complaints to the CEU. We don't need to be tenants of that building. So I made a complaint to the CEU saying, look, we have this decision from the arbitrator saying they don't have funding to provide transitional housing. So they need to stop taking this position. They're transitional. The act applies. And so the CEU decided to actually investigate. The CEU has a lot of issues too. I don't want to say, oh, the CEU is completely great. And there aren't, of course, there are certainly issues. And I'm sure many of you have come across some of these issues. But one of the biggest issues is the complainant doesn't know the outcome of the complaint. They don't have to tell you the outcome of the complaint. So when I checked in to see, hey, what's the progress on my complaint? I was given a response, but I was told that was a courtesy and that they wouldn't continue to give me a response. But at that point, I was told the compliance and enforcement unit was working with this nonprofit landlord to help them come into compliance with the RTA. So I took that to mean, okay, the landlord must acknowledge now, or the CEU has told them, look, the RTA applies to you, and they were changing their policies now to reflect that. So I think it works. I don't have a final decision to confirm that, but based on that feedback I got, and I believe the investigation was still ongoing, I took that to mean like, okay, well, they're talking about compliance with the RTA. So there's some acknowledgement that it's applying. So I think this could be a strategy for all of us to possibly take in the future when we are assisting tenants with this jurisdictional question, to then assist the rest of the tenants living in that building who may also benefit from having recognition that that particular building falls under the RTA. So I think compliance and enforcement unit is just another tool we may have at our disposal to address a lot of these issues. And their powers have actually recently been expanded. So now they can compel more diverse evidence. They can also compel evidence from third parties that may have relevant information as well. So I think the CEU can certainly be a tool that we can use to address these issues at a more systemic level, rather than having to constantly go to the RTB and make individual applications for each individual tenant, which can be very onerous. And, there might be an easier way to have recognition that a building needs to either stop a practice or start a practice that they're required to do. So just that last slide just gave you a bit of an overview of the kinds of things that the compliance enforcement can do. And I think their greatest power is their ability to levy an administrative penalty, and that administrative penalty can be up to $5,000 a day. And they also have a lot of teeth. This is one thing I wondered about. Okay, you have this ability to levy an administrative penalty, but you have teeth to collect it, and they do. I believe it can go to the Minister of Finance. Like there are some definite powers there for them to collect on their administrative penalties that they can levy. So I'm just seeing a question here. Can the CEU compel the landlord to produce their funding agreement? Very good question. I think they should be able to. I think they should. The question, I think, then becomes, will they? So I think if you went to the CEU and tried to do this similar jurisdiction question, I think you can certainly ask them to do that. I think they should do that. That makes sense, for their investigation. That would be pretty important for them if you're questioning jurisdiction. So I think they have the ability to. Whether or not they will is what I'm not sure about. But something for us to discover moving forward if we're going to use the CEU as a tool in this way. Another thing, just to give you all a heads up, we certainly have made a massive FOI request to actually try to get all of these operating agreements from a bunch of different buildings. So when that eventually comes, which will probably be months, absolutely happy to share what we find. And if any of you want to just reach out and say, hey, I'm working with this building, did you happen to get the request through FOI? I'm hoping that maybe we can do some sort of library on that where you all can come to us and see if we have that in that giant FOI request that we're making. Because sometimes, you don't have the time to actually wait to get those agreements from BC Housing through an FOI request. So the aim here is, just have these so people can access them, especially if they're assisting a tenant who has a situation that is restricted by time. So that's the goal. I'll definitely keep you all updated on how that's going, but I think it'll probably be months and months before we get there. So I see another question. We usually get a standard response from the CEU that there needs to be an order before they will get involved. Yes, absolutely. So I think, yeah, in the example I gave with the tenant that I helped, we did get a decision that said, the transitional housing this is not transitional housing. You don't receive funding from the government. You also don't meet these other criteria. So in that situation, we did have the order from the RTB, so the compliance and enforcement unit did intervene. But absolutely, that's true that the CEU sort of sees itself as a last line of defense. Come to them after you've exhausted the RTB processes. So that's a good point. It's really, yeah. If again, in using the CEU as a tool, it's not a. I wouldn't say that it may not be. I think it still remains to be seen how useful it can be as a tool or how useful they may be, because I know a lot of people don't have great experiences with them. I've heard many folks, many clients of ours who have tried and they've been very disappointed in the process. So we'll see how useful we may find them to be. But I think what's interesting is there's now maybe this tool that we can really see what the boundaries are and how we can really maybe push some of this stuff with them. But yeah, that's a good point. They do want the order firsthand. So it's probably a good idea to first go to the RTB, get that order. And if it's not being enforced, then the CEU can be your next.
Yeah. And as I said,
option.
We could as I also said when I talked about it, it's possible that we, as we want to share, like, for example, I shared my decision, right? Like, I'm like, okay, this is the decision. Like, if we have we could, I don't know if I have the capacity to do it, but like maybe someone or somewhere we can build like a database of like, if it's like a common occurrence, like for example, guest restrictions, you could try to build a database of like, okay, we have orders against all of these housing societies or nonprofit housing providers. And as Danielle, I think also like in a lot of the cases where it's like the Supreme Court said it, it's like, okay, you could also try to be like, look, okay, maybe an arbitrator has said it and a Supreme Court has said it, like they're just clearly breaking the law. You could try to say that in cases where you don't have a director's order, but otherwise, yeah, I think the way forward is like, yeah, go get an order. And then if you ever have someone from the same building or housing provider again, you can be like, okay, look, hey, see you, they're doing it again. Sorry, Daniel.
Oh yeah, no. That's a good point. Just going back to the chat, are any of these requests for NPHA outside of the Lower Mainland? I am not sure. Would you be able to maybe clarify the question? It's probably because I'm sure the question came in as I was talking, so I'm just not sure what requests. Requests for NPHA. Oh, yes, your FOI. Yes. Most of their requests, the way it's worded, and this is the thing with FOI requests, you never know what they're going to come back with. The way it's worded is actually all operating agreements BC Housing has with nonprofit housing providers, which can be a lot. So that's why we've worded it very broadly. I don't have a ton of experience with FOI requests. We're actually working with some professors at UBC who do on this project. And yeah, I think the idea was start broad, but sometimes they come back and they might say, that's just way too much. Can you define it more? So it's possible, but the goal is to actually get whatever agreements BC Housing was with nonprofit housing providers. So we should get some from outside of the Lower Mainland. So thank you for clarifying your question. Another question, I have tenants telling me that the CU not contact them and they will not know if they were going to do something about it. Yep, very true. Also, the time for the CU can be very long. Do you know the approximate time for an emergency repair order to be enforced? Absolutely. Again, a lot of problems with the CU for sure. And I think the biggest one being, yes, it takes a lot of time for them to do anything. And it does absolutely, they are silent on what the outcome is. Again, you make a complaint, you have no idea what's happening. So I think, and I know in some situations, tenants have followed up and nothing. Admittedly, I think I got a follow-up because I know the director just through stakeholder meeting stuff. And so again, he explicitly told me it was a courtesy. So I know that the situation I was in seemed to be exceptional. It didn't seem to be what they would continue to do, which is obviously a problem. In terms of the emergency repair order to be enforced, I believe they do try to prioritize urgent situations over non-urgent situations. So I think if you were to note, hey, this was an emergency repair, it was supposed to be done, it didn't, I need urgent intervention. I think sometimes they do have capacity to do that. I have heard from other folks in the past, tenants and advocates, that they've responded very quickly to a legal eviction, sometimes the same day. But I think that depends on their caseload. I think that depends on their resources. Sometimes they're down staff, sometimes they're up staff. So I feel like they're in flux often. So I think those factors will depend on the resources at the time. But I have heard that in emergency or urgent situations, sometimes they can respond within the same day. But again, one of those things, I think we're just sort of still figuring out, how useful are they going to be? What are their boundaries? What can we push on them as advocates and tenants as well, because they're doing that too, right? They're well aware of the CEU, and tenants are doing a lot on their own as well as they typically do. So yeah, so that's a bit about the compliance. Yeah, sorry, go ahead.
I've used them for illegal logouts a couple of times. So I have some experience with that. I think I've done it 4 times. In all of the cases, they got back like within 48 hours, most of the time within like 24 hours. So they are pretty fast to illegal lockouts. You don't need to do dispute resolution first, but you usually want to do both at the same time. Like usually what I do is like I apply for dispute resolution, make an emergency hearing for tenant's order of possession. Then I email the enforcement and compliance unit like, hey, I have a tenant being illegally locked out. This is the file number. You can see all the information there. You can see all the details there. If you should probably talk to the landlord, see if can we do anything faster because the tenant is like homeless and suffering. And that's probably the way to go about it. They usually come back pretty fast. I don't know if
yeah, and just another comment in the chat, opposite experience with the legal lockouts where the CEU took no action and said DR resolution was the way to go. So yeah, it's a really tough call. You get so many different experiences with the CEU. Obviously some situations where they are responsive and absolutely situations where they're not responsive. So it's not something that I think we can rely on. Absolutely. It's not something that we know with certainty will resolve the problem. Certainly things to moving forward, make them aware of, address these things at a systemic level, at a policy level. And one of the biggest issues at the RTB is just the lack of resources, the constant lack of resources, and people not being trained, and people not either decision makers or information officers or people who work for the CEU. It's certainly not reliable. I think you can try it and you're really not going to know what you're going to get. So important to keep in mind, absolutely. And just the last slide we have here is just sort of, so where is the law heading with all of this? I think I can recall some of what's on that slide. So I think a lot of us know that the nonprofit housing sector has constantly lobbied to have supportive housing exempt from the Act. So that would effectively mean all nonprofit housing is exempt from the Act, or most nonprofit housing is exempt from the Act. That's been their position for a long time. We also had the Residential Housing Task Force recommendation number 22, which is super broad, super vague. It just says address the specific needs of nonprofit housing and supportive housing providers. And then some further explanation given is supportive housing providers also ask for the Act to be modernized. Don't know what that means. To reflect the growing complexity of providing supportive housing. For example, the need to do wellness checks in housing for people dealing with substance use challenges. Obviously, even the wording of that is problematic. But clearly, this is one-sided. Clearly, there's nothing in this recommendation that says, oh, we'll actually talk to tenants. We'll talk to people with lived experience, either current or past, and see what their needs are. It's one-sided. It's all about what does the nonprofit landlord need? So immediately that's a red flag, which seems to suggest, oh no, they're only going to be consulting landlord groups here and landlords. There's no interest in hearing from tenants or tenant advocates. And we've certainly urged government and the RTB to ensure that they are also consulting tenants, that they're consulting tenants with either current lived experience, previous lived experience, tenant advocates, that this cannot just be one-sided. And they say they will, but I doubt it's going to happen, or I doubt it's going to happen in a way that's actually meaningful. So something to just keep in mind on the horizon is this could be where this all goes, or another alternative. And I think this alternative might be more likely, which is just supportive housing is not completely exempt from the Act, but exempt from certain provisions. So exempt from provisions that limit landlord's ability to restrict guests, limits the landlord's ability to access the unit, things like that, things that would allow them to continue to do wellness checks, to continue to put in guest restrictions. I think that might be a more likely possibility than a complete exemption, but I don't know what all you think or what you may have a feeling about, or what you've maybe gathered from talking to politicians as well. But, and if you have any thoughts, please share it in the chat. But I'm thinking we're heading to a place where there are going to be some exemptions, or these nonprofit landlords are going to be given the ability to not observe certain provisions within the act. So that's concerning. And then of course, we also have, what do we do, with cases like Richardson, Rutherford, and Swaite that we discussed. Lassie pointed out already, we have these BC Supreme Court cases. Could we go to the CEU and say, hey, look, the BC Supreme Court has already said you can't have a building-wide guest ban. You have a building-wide guest ban. So CEU, do something about it. Are those going to require adjudication? Obviously, a decision maker, someone's going to need to test the evidence on that. I don't know that the CEU is going to take that position. They may say, no, we still need, you didn't give us enough evidence. We're not certain that there are guest restrictions or bans here. Go to the RTB dispute resolution process first. But I think the other issue is, like, how do we monitor these things? Because we can have these great cases like Richardson, Rutherford, and Swaite, and then we can have the situation we're currently in, where the nonprofit housing providers just kind of ignore that, or think they're above the law and don't have to observe the law. So what can we do as tenant advocates supporting tenants? What can we do to sort of ensure that there's accountability, that there's monitoring? And the tricky part is, we all know we're all overworked. That is a huge undertaking to have to do that, to have to monitor. But certainly something to just sort of think about, because it's like, what are these wins if they mean nothing, if they're not being implemented, if they can just be ignored the way that they've been. So something that I think, certainly many of us probably think about often, and something that I'm sure we're always struggling with. We can maybe do something positive here, but is it going to be sustainable? Is it going to last? Is it going to actually affect anything? So just something to keep in mind when we think about all of this. And I think there are just a few, there's one question here.